All rise. The Honorable, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon. Folks, sorry we're a little late. Judge Jackson had an emergency and we had to find a replacement. So Judge Hampson is going to, and we'll enter an order substituting him on the panel for that. So welcome to the North Carolina Court of Appeals. And we have one case this afternoon, Walker versus Baker. And we are prepared for the plaintiff. Have you indicated how much time you'd like to reserve?
Yes, sir.
You've told the clerk already. Okay. Okay. We'll hear from you.
Good afternoon. Good afternoon, Your Honors. My name is John Kirby of the Wake County Bar. I represent the plaintiff appellant Wesley Walker. In this case, we are here today on issues of qualified immunity raised by the sheriff defendant, also official immunity raised also by the sheriff defendant, and a privilege called the fair report privilege raised by the media WTVD. Just by way of background, the basic facts of these cases are my client is Wesley Walker. He is trained and licensed as a certified nurse assistant. He worked at a business here in Raleigh called Capital Nursing, providing CNA services. A false allegation was made against him by his father-in-law, a Mr. Darry Chavis. He alleged that Wesley had assaulted him. That was a false allegation. But for purposes of this appeal, that had nothing to do with Mr. Walker's job as a CNA or his work with the Capital Nursing. Somehow this came to the attention of the local media, WTVD, and they, upon first looking at this, they inferred this was a domestic matter, which in fact it was. They then reached out to the sheriff's office to determine whether this had anything to do with his employment at Capital Nursing. The sheriff's office then responded back to WTVD and stated that in a 4-word email, they said related to his employer.
And then, Mr. Kirby, with respect to the media defendants, you've sued them for defamation. Is that correct?
Yes, sir.
And is it correct that what the story said was new at 6, a Wake County man who works with the elderly is facing an assault charge. Wesley Walker works for Capital Nursing. According to the warrant, Walker hit the victim in the face with a closed fist. The sheriff's office telling us the charge is related to his job. We reached out to Capital Nursing, but so far they have refused to comment. Is that the substance of what we're here on?
That is correct. Yes, sir.
And what about that, with respect to the media defendants, what in that statement is false?
Okay. The statement that is false is that this assault, which of course didn't happen anyway, but assuming it did, that this assault was not related to his employment, was not related to his employer.
But the media said the sheriff's office tells us it is.
Yes,
they
sir.
did not make that statement directly, did they?
Yes, sir, I understand. So in a hyper-technical sense, that statement is correct. But North Carolina, as well as most jurisdictions, follow what is called the Republication Rule. I've cited that in my brief. WTVD has conceded that rule exists. It basically means if you repeat exactly what someone else said, and even if you attribute it to them, you are still liable for libel or slander. In other words, you don't get a defense if I simply say, oh, John Smith told me that he murdered him. Even if you put those qualifying words in there, that is still considered libel and slander. That we loosely call that the Republication Rule. So yes, in a technical sense, what they said was correct. The problem is that what the sheriff's office was reporting was incorrect. And that's the part about the story that was defamatory toward Mr. Walker. Yes, sir.
Go ahead, Adam.
Yes, sir. So, but just as far as I guess I was getting to the basic facts. So WTVD did reach out to the nursing home to see if this had happened. They were informed by the nursing home that there was no one there by the name of Derry Chavis, that would be the alleged victim, and that no such incident occurred there. They also apparently tried to reach Capital Nursing through their website, but the Capital Nursing had not responded as of the time the story aired. They also did not try to reach out to my client, Mr. Walker. At 6 o'clock, this would be April 2019 or August, this story ran at the 6 o'clock news. My client happened to be working at the time at Capital Nursing. He actually saw the story. Others there saw the story. He was embarrassed, shocked, humiliated, and perhaps most importantly, he lost his job at Capital Nursing as a result of this. He has a loss of income. He thereafter had to work doing things we've alleged, such as working at a pizza restaurant instead of working his chosen profession. The defendants have agreed that the charges here, in fact, now have nothing to do with Capital Nursing, and that was, in fact, an error in the report. That the report was incorrect, and that point has been admitted and conceded to here. The issues that are raised on appeal is one of the defendants filed a Rule 12b-6 motion to dismiss, the other a Rule 12c motion. Those are very similar motions in concept. On the standard of review, this is a de novo review, and on that review, the allegations are taken as true in the complaint. We also do have some of the actual documents at issue, and I think what you were reading from before Judge Arrowwood was perhaps a transcript of the actual newscast as it ran. The arrest warrant is also in this record. With respect to the sheriff, I will start with them, and again, if any of you have any questions, please cut in here. But with respect to the sheriff, the defense that they raised is what is called a qualified immunity. North Carolina recognizes there's a doctrine called qualified immunity. There are not a lot of cases on this doctrine. And so for that reason, you might notice in our brief, we do cite to the restatement, we cite to law from other states where we have a gap in our law. And on many occasions, our courts have looked to the law of other states. But North Carolina has articulated a qualified immunity. This, in some jurisdictions, is called the common interest doctrine, but it's the same concept. The case we cite for the basic elements is Clark versus Brown from 1990. But there are 4 elements that they have to prove. It is their burden, it is their affirmative defense to show that this doctrine applies. The first element is that the matter on which they're speaking, that they have an interest in that matter. The second element is that the person receiving the information have a corresponding interest in the matter. The third is that it be a privileged occasion. And the fourth, it says, and it's under circumstances warranted by the occasion. We do agree here that the sheriff's office has an interest in this. We're not disputing the first element. The sheriff's office obviously has an interest in investigating assaults. The other 3 we contend do not apply. Elements 2, 3, and 4 here sort of blend together to some extent, so my arguments would overlap on those. But the biggest and main reason that it does not apply here is because there is not, in fact, a corresponding interest between the sheriff's department and the media over this. This is the number one reason this doctrine does not apply. We don't doubt that the media and the public in general may have some interest in crimes and assaults and what happens in nursing homes, but the issue under this doctrine is whether there is a corresponding interest in that subject matter. And both sides have cited some cases that I would submit are instructive on how this doctrine is intended to apply, and in particular what this element means. And just to be clear and put this in context, obviously the sheriff investigates crime, arrests people for crime, and that sort of thing. In this case, the news media was not a witness to this crime, was not a victim of this crime. They had no relation to this crime. They are simply trying to report this crime to the public, and that is the fundamental reason why there is no corresponding interest between the two.
So it's your contention that the media has no interest in knowing about arrest records or anything like that?
I would actually argue they do have an interest, and I would submit that the public in general has some interest in being apprised of crimes, criminal activity, arrest warrants, that sort of thing. The issue as the elements have been stated in our case law, other persuasive case law, is that it has to be what they call a corresponding interest. So the point is it's not just any interest, it must be a corresponding interest. And the cases from North Carolina that have been cited, and I would also submit some of the cases from out of North Carolina are instructive on what this means. The two primary cases cited by the sheriff in support of the defense, one is called Averitt, A-V-E-R-I-T-T. The other is called Market America. Those are prime classic examples of where this would apply. In the Averitt case, for example, a police officer was investigating an allegation of a murder. It appears that there was an allegation that a husband to a domestic dispute had murdered his wife's private investigator. So the police are investigating that, and they speak with that man's ex-wife, and they go and find the private investigator. Fortunately, he's not dead. But during the course of that investigation, that police officer makes the defamatory statements that he had heard that the husband had killed the private investigator. And so later the husband sued that investigator. He sued the police for defamation, saying, hey, you went around speaking with people, you defamed me. The officer was able to defend and say, look, I was speaking to someone who may have knowledge about this, that would be the wife. I was speaking to the person who was allegedly killed. Those statements are privileged. And this court of appeals says, yes, that is privileged. You, meaning in that instance, the police and the victim and the witness have a common interest. A similar situation was presented in the Market America case, which I can go into. That was in the context of a business that issued defamatory information internally within the business to people within the business about a third party. And this court held that in that context, that business was justified and got the benefit of that privilege because this, again, was distributed within the company, and it was done to protect the company and to promote the company's interests.
If this had been a document that the sheriff's office had given to WTVD and it contained this statement, would that have been available for qualified privilege in your view?
So from the standpoint of the sheriff's office, if I'm sorry, I have to keep the two defendants have different doctrines that kind of overlap, and I have to sometimes pause a moment to keep the two lines straight in my head. If all that the sheriff's office had done here was to give the media an accurate copy of something like an arrest warrant or a warrant for arrest, some truly public document, then I would submit meaning the person giving that information, could not be sued for that. If all they did was turn over, let's say, an arrest warrant, even if that arrest warrant contained incorrect information, the sheriff's office could not be liable for that.
What if it said somewhere, written on there, this relates to his job?
If that were in the arrest warrant, let's say somewhere in the arrest warrant that had been written, then I do believe the sheriff's office would basically could not be sued civilly for simply disseminating that public record. There's another doctrine that actually dovetails with things like arrest warrants. There's a judicial, there's what we call an absolute immunity that applies to statements made in the course of judicial proceedings. But yes, this is a fundamental distinction in this case. If the arrest warrant had that incorrect information in there, then yes, I think that would present a very different situation. But that's one of our points here is that, and this gets to actually the issues with respect to both defendants, but the sheriff's office, of course, they went beyond what was in the arrest warrant. The arrest warrant says nothing, as I read it, about capital nursing on the job related to his CNA. Can
I ask just a quick question about the warrants? When are we looking at this 12B6? Are we solely looking at the complaint, or there were things attached to it? Was it converted to a motion for summary judgment? How do we deal with that?
Right. It really was not converted to summary judgment. There's a line of cases which says that in essence, if you reference certain documents in your pleading, those documents can then be filed and become part of the record. It's kind of a strange doctrine, but basically it does not convert that into a summary judgment. But that document must be fairly referenced in one of the pleadings. A classic example would be if someone filed a case over an insurance dispute and didn't attach a copy of the insurance policy to that, the other side could introduce that policy. So I do submit that is properly in this record. We made reference to the arrest warrant. They have filed it It's a good question, but I think it's fairly in the record. If I could I'll just continue to address briefly the issue of the qualified immunity. A couple of the cases I think are more on point here. They are out-of-state cases, but again, the law across the country, it is developed in a very similar fashion. But there are two cases that we cite in which individuals made statements at a press conference, which is why we contend that's more analogous to what we have here. This is not simply giving an arrest warrant to the news. This is a communication directly from the media, between the media and the law enforcement. Both of these cases coincidentally happen to involve basketball. That's a pure coincidence. But in one of these, the Orlando Magic had issued a press release about one of their assistant coaches that he claimed contained false information. In the other case, you had a high school coach out of Indiana made a similar allegation that his high school team had disseminated false information about him at a press release, and the argument was made, this is protected by this qualified immunity. The argument was made, hey, we have some interest in notifying the public of what's happening here. Just for example, in the case with the high school basketball player, the allegation was he threw a basketball at a player. So the argument made is, hey, the community has a right to know what this guy's doing and what's going on at our schools. And the court held that the media does not have a corresponding interest with, in that case, it was the school, but with the school over that issue. They said, of course, the media has nothing to do with the basketball games, with the players and so forth. The court went on to say, and I submit this is very instructive, that if that school had only disseminated that to the players and their families, those entities have a sufficiently related or common interest to invoke the doctrine. So the basic idea is that simply giving information to law enforcement does not invoke, giving information from law enforcement to the media does not invoke the privilege because they don't have the common interest. Again, I don't doubt the media has some interest in running the story. Public may have some interest in the story, but there's not a common interest sufficient to invoke that.
Can I just ask a quick terminology question? I sort of bouncing back and forth between these concepts of qualified immunity and qualified privilege.
Yes.
I guess I'm viewing this through a lens of more qualified privilege. The idea of I mean, is there any daylight between those terms? Am I just reading too much into that?
I'm not aware there is. I sometimes get the terms confused myself. The other doctrine at issue in this case is called the fair report privilege. There is also a doctrine called absolute immunity. That typically refers to statements made during a judicial proceeding.
Or the absolute privilege, I guess.
Yeah, exactly. I do think I more typically hear the verbiage qualified immunity. I believe I see that more often. Yeah. I'm not sure if someone had a question, but so we would submit here that in essence there is no common interest between the media and the sheriff. Just a couple of last points on the issue about the sheriff's dissemination of this information. The cases that talk about this, including cases in North Carolina, they again say that you have to look at the public's interest in the particular story. We cite a couple of cases in our brief, a case called Shooping versus Barber and a case called Boston versus Webb. But these cases, they basically stand for the principle that you have to look at what is the public's interest here. And in this case, I submit this is important as well. Certainly no assaults are justified. Assault at an assisted living facility would not be justified, but it's important to put this story in context. It's not as if this was made, it's not as if the law enforcement made this statement to try to get information about a crime. It's not as if there was an ongoing crime. This, again, may be different. We have different balancing. Let's say someone's on the loose and the sheriff issues some statement or press release, or let's say the sheriff's office is looking for evidence to prosecute. None of that is presented here. By all accounts, even if this occurred, this would just be one isolated event. So again, the courts look at the context of the situation to see whether it should be qualified. As just an example, in the case of Boston versus Webb, I cite, in that case, a town had alleged that one of its police officers had been accepting bribes, and they came out and they disseminated that information. And the officer then sued them for defamation, and the town said, hey, look, we have an interest in clarifying that, in telling members of the public that this officer was accepting bribes. It came to this court, and this court said that more facts were needed to see whether that in fact sufficiently invoked the public interest to warrant application of that doctrine. So for these reasons, we contend the sheriff does not have the immunity that he asserts here. I'll turn briefly, so my time is getting a little bit lower, but to the issue of WTVD. They have asserted something called the fair report privilege. This is essentially a doctrine. There are, again, only a few cases in North Carolina on this. There is, I would submit, a very good provision from the restatement of torts. I believe even WTVD has cited to that gives us a lot of guidance on how this should be applied. This basically is a doctrine that protects someone if they repeat something, a report of some sort of official action, or if they report the events taking place at an official meeting. And of course, under this doctrine, if it applies, the media has to show that their report was fair, and fair is defined in different ways, but it has to be substantially accurate, and they can't omit anything that substantially changes the import of the story. There are basically two reasons why we contend the fair report privilege doesn't apply here. The primary of these is this. The real problem here that caused this defamation to occur is that the sheriff sent, through what's called Public Information Officer, a 4-word email which stated related to his employer. That was the problem. That's what set things in motion. This is a 4-word email. This is not a warrant. It's not an indictment. It's not a report by the sheriff's office. It's not a report by the town council or the county. This is a 4-word email. So our position is that this doctrine we're talking about, the fair report privilege, only applies to some type of an official report, not just an email, not a one-on-one communication between law enforcement and the media. The language from the restatement, which is helpful on this, the way they word it is, they say the publication of defamatory matter concerning another in a report of an official action or proceeding, etc., is privileged. In this case, we contend first and foremost that 4-word email does not get the benefit of this doctrine. We have cited some cases. In the interest of time, I won't go into detail, but in 2019, the Tennessee Supreme Court had an almost identical case in which a public information officer did the same thing, one-on-one communication. It resulted in defamation against the plaintiff in that case. It goes to the Tennessee Supreme Court, and their Court of Appeals unanimously held this doctrine does not apply to one-on-one communications. We've also cited a case out of Nevada and out of New Hampshire addressing the same issue. Those are the highest courts in those states addressing this issue. North Carolina doesn't have anything on this precise issue. But this doctrine basically fundamentally doesn't apply to just anything that someone within government says or does. The second point is, so the first point is this was not an official report, it's just a 4-word email. The second point is that in order for them to get the benefit of the privilege, it has to be what we call fair. And fair means different things. In this case, there are several reasons why we contend this report was not fair. At its core, however, they had information when they ran this indicating, well, let me back up. When they first got it, they assumed it was domestic, which it was. So they already had indications it didn't relate to his job. When they reached out to his job, they obtained more information that it didn't happen there because the Capitol Nursing said there's no one here by that name, and that didn't happen here. Nevertheless, they ran the story. And again, I submit context matters. It's not as if they're pursuing a fleeing felon or trying to chase someone down. There's no urgency in running this story. They hadn't yet spoken with my client. I believe my client has appeared here today. I don't think I gave him very good directions earlier, but Mr. Walker is, I believe, with us here today. But basically, the contention is under the fair report privilege, it has to be fair. And to be fair, you cannot omit critical things. We've cited a few cases in our brief. 2 happen to be from New Jersey, 1 is from the Third Circuit, but they just address this issue. Again, unfortunately, there's a paucity of North Carolina law on this, but it basically stands for the principle you can't omit important things from your story. They could have easily either A, not run the story, or B, if they wanted to run the story, they could have simply said, Capitol Nursing has told us that a Mr. Derry Chavis isn't a resident there, and this didn't happen. They could have easily put in the exculpatory, but you basically can't cherry pick the information that you're giving and give them only the good, only the inculpatory information without the corresponding exculpatory information. And so that's the second reason the fair report privilege doesn't apply here. It simply wasn't fair. So I sort of jumped through the issue with the media rather quickly in interest of time. I think I'm down to about 1 more minute before I hit the 5-minute mark. So if anyone has any questions, I'll be happy to.
I just have one question.
Yes.
So, have you alleged actual malice in this complaint?
No, I haven't. And to be clear, I'm not alleging malice here. I'm not alleging that. One argument that reminds me, I didn't get to my arguments here. The sheriff has also raised the issue of official immunity. The argument there would be that their public information officer is a public official, and he's entitled to immunity unless he acts in malice. Our basic position is he doesn't have and exercise that type of discretion. We cite several cases in our brief where our courts have held that a state physician, EMT worker, crossing guard, special needs teacher, others don't exercise that degree of discretion. And certainly this is on the pleading stage. We haven't really even gotten into the specifics of what his job entails. But they have raised that on appeal. Just to be clear, the lower court did not rule on that. But they have raised that on appeal, and we have put that in our brief. But I think I'm down to 5 minutes, so unless someone has a question, I'll take my seat.
Fine.
Thank you.
We'll hear from the appellees. Mr. Ellis, I assume you and Mr. Buchan have agreed among yourselves how you're going to divide up the argument.
That's correct, Judge. On behalf of the, what I'm going to call the sheriff defendant, Sheriff Baker and Mr. Curry, I'll take 15 of our minutes, and Mr. Buchan will take the remaining 15 minutes if that's acceptable to the board.
Fine.
Thank you, Judge. Again, Nick Ellis, I'm here on behalf of Sheriff Gerald Baker, the Sheriff of Wake County, and Eric Curry, who is sued in his individual capacity as the public information officer for Sheriff Baker. Judge Rozier, the trial court judge, entered an order granting the motion for judgment on the pleading of the sheriff defendants, and this court should affirm that ruling. Judge Rozier found that qualified privilege was applicable as a defense to the claims being made by the plaintiff. In order to do so, he found that the communication between the sheriff's office and WTVD was made on a privileged occasion, and that it was within the confines of qualified privilege.
So what's the privileged occasion here that information officer, what gives him, what's that? That's the question I had, is what's the privileged occasion?
And I think, Judge, that's probably the first layer of questioning related to the application of qualified privilege. Plaintiff's counsel just admitted you have to look at the context of the communication. And I couldn't agree more, because as we pointed out in our brief, the context of the communication was that WTVD had the public information related to the arrest warrant, and then WTVD, Ed Crump, I believe was his name, he asked Mr. Curry if he could have information about was this related to his employment. And we know the response was related to his employer. All of the cases the plaintiff has cited in his brief are unilateral, voluntary communication from the speaker. In this case, the communication was mandated by North Carolina general statutes. As we pointed out, under General Statute 132-1.4c, the following information, and I think the court asked earlier about records versus information, and the Public Records Act in North Carolina does identify public records and public information, so they are two different things, but under the statute, it is public information about the location and nature of a violation or apparent violation of the law reported to a public law enforcement agency. So again, the context of this is that the reporter, WTVD, makes a request for information. The statutes mandate that that information must be disclosed to the requestor. So that is the context. And so to answer the court's question further, why is this a privileged occasion? And of course, privileged occasion means that it is something that the public has an interest in. I don't know that we could find an example of something that establishes that the public has a significant interest in information other than a state statute that says it's entitled to the information. More importantly, what makes it critical information, this same statute, 132-1.4, says that if the requestor is denied the information that he or she seeks or it seeks, that it can file an action with the court, and the statute says which the court shall immediately hear.
So
Not only the trial court, but the appellate court.
I'm sorry, I didn't mean to interrupt you.
No, ma'am.
I guess I'm having a hard time connecting those two when we're talking about the information must be disclosed, correct? Because it was asked for, correct?
Correct. That's right.
But there was actually no information to disclose in this case because the information didn't come from anywhere. It was created, right?
No, and I think what the plaintiff wants to argue is if that information is not on the face of the arrest warrant, then there is no other information that can be disclosed. As we set out in our answer, the request comes in to Mr. Curry, the PIO. Mr. Curry reaches out to the Criminal Investigation Division. They provide him the information necessary to answer the question. So we have alleged, and it's stated in the complaint, it was not denied in any subsequent pleading, and as the court knows under a 12C motion, it's the complaint, which is those factual allegations, not conclusory allegations, but factual allegations are taken as true. Similarly, and plaintiff's counsel did acknowledge if transactions, documents, whatever are referenced in the complaint, the fact that they are attached as an exhibit to an answer does not convert a Rule 12 motion to a Rule 56 motion. And similarly, if allegations are made in the answer that do not contradict or refute the allegations in the complaint, then those allegations are treated similarly and are deemed to be true. So Mr. Curry does some further legwork, reaches out to the CID, takes that information. They're the ones that investigated. They're the complaining witness. They're the law enforcement agency that actually takes out the warrant. So there's more information than name, rank, and serial number, which is essentially what's in the arrest warrant. So that is the source of the information related to his employer that Mr. Curry then, because he is required to identify and produce and disclose location and nature of the violation or apparent violation.
What is the information related to his employer? Where is that in the Sheriff's Department's records that that this warrant relates to his employer? Where is that information?
At the current stage, that information is in the answer. As far as backup documentation, we don't have that before us. That's why it is pled in the record, and it's not contradicted anywhere, and it does not.
Well, how could they don't have a right to reply to your answer.
I'm sorry?
You didn't file a counterclaim, so there's no right to reply to refute that. You say they didn't refute it in any subsequent pleadings.
Correct.
How, but they don't have a right to a subsequent pleading when you file an answer with affirmative defenses, do they? Do they have a right to reply there? Have I missed something in my?
They certainly have a right to petition the court to file a formal reply.
They do have a right, but there's no right in the rules.
It's not required, I think is what Your Honor is getting at.
Well, it's not required, and unless you ask for it, you don't have a right to it either. You've got to ask the court to do it.
That's correct. That's correct. But again, under Rule 12C and in the plaintiff's own brief, it states that the pleadings that the court can consider at this stage and the pleadings that Judge Rozier considered, again, it's not just the complaint, but it is the answer to the extent that the answer does not contradict allegations that are in the complaint. So the plaintiff did not make any allegations one way or the other about what investigation anybody else at the sheriff's office had done to determine the connection with the employment, did not make any allegations about what Mr. Curry had done to determine how he had information that it was related to his employer. So it is stated in the answer, uncontradicted, that Mr. Curry reached out to the Criminal Investigation Division, and then with that communication, takes that information and passes it on to WTVD. So that's how it is a privileged occasion. And again, as the court knows, the Public Records Act has some very strong language. Public information, public records, it states in 132-1B, it is property of the people. And again, plaintiff argued earlier about the context of the communication. The Orlando Magic case, that was a case where a private entity said, we've got a disgruntled assistant coach, we're going to terminate him, and we're going to unilaterally issue a press release. Well, there was no corresponding interest by the recipient of the information, the general public. The same thing with the Indiana basketball coach situation. And then the Iowa case, it was a court case. Plaintiff's lawyer, I believe, had unilaterally taken the pleadings to the media and basically said, here, you can run this story. So absolute privilege was not recognized in that case. But in this case, again, the context, the sheriff's office is not responding and providing this information in a press release. It's not doing it voluntarily. A request for information that is public information is made, and the sheriff has to respond.
But they don't have to make it up. They don't have to make up the information if it doesn't exist.
No, that's correct. That's correct. And I don't believe there's an allegation anywhere, complaint or answer, that it was made up. Again, there's no refutation of the answer that says that Mr. Curry communicated with CID and passed on the information.
But your argument seems to suggest that one division of a sheriff's department can simply make up information that is not true, or have information that is not true, communicate that to another part of the sheriff's department, and as long as that's the public information department and they disseminate it, there's a privilege, even though there was absolutely zero basis to make that assertion.
Well, and that's the whole basis of privilege, though, is you have communicated incorrect information. I mean, if it was what the court is implying, there would be no such doctrine or defense as qualified privilege.
Well, that's not true, but I mean.
But what the privilege does, it allows a mistake to be made without there being a recognizable claim for the plaintiff. And again, in this case, this is the context of it. The right, they stipulated to the first element, that the Wake Sheriff certainly has a right to this information.
Where in your answer do you allege that the Criminal Investigation Department obtained information that this was related to the, and how did they obtain that information that this was related to the employment?
That is not included in the answer.
No. So is there not a question of fact, at least there, that needs to be addressed as to what the basis of that, of the Sheriff's Department knowledge of this information?
I don't believe it does create a factual question, Your Honor, because again, what we've got here is the context of the communication. For the purpose of this hearing, it's false information. A mistake was made, but that is not the end of the legal analysis. The question goes back to the context, the mistaken communication, how did it come about? And it came about because there was a request for public information that the sheriff is required to provide and disclose.
Why is this not a question, though, to be determined at Rule 56, where your client may well win, as opposed to a Rule 12?
Well, Judge, I think the law is very clear. This is a question of law, unless there are disputed facts, and there are no material disputed facts relating to there was a request for information, very specific request. Was it related to his employment? And of course, under 132-1.4C2, public information is the employment of the alleged offender. And again, the location and nature of the violation is public information that has to be disclosed. So there's no dispute about any of that. There's no dispute about what the statute says, no dispute about what was communicated. no dispute that it was incorrect, unfortunately. But again, that is why qualified privilege exists, because WTVD has a right, a corresponding right to this information. And the Public Records Act says that the information must promptly be reported. And again, the sheriff has to provide the information requested if it falls within the categories identified under paragraph C.
So just to follow up on that, I think I heard one of you say that the employer was reached out to, correct, and they said, we don't have anybody by that name. The sheriff's office have that information as well?
No, ma'am.
Okay.
There's no allegation in the complaint about
Okay.
that. I think it was WTVD reached out to the employer,
Okay, so that's
provided to
different.
WTVD,
Okay.
and it was siloed over there, if that's
Okay.
correct. So we think that, and again, the extent of the communication was not excessive, which is the fourth element of qualified privilege, and we think that that was certainly met and that Judge Rozier's ruling should be affirmed. Similarly, we did raise the defense of public official immunity. On this, we have talked about in our brief, we start with the sheriff, constitutionally created position, 162-24, statute that permits the sheriff to employ others to assist him with public duties. We've been talking about the public duty that is required under 132-1.4 to provide this information. Plaintiff alleges that, well, that's a ministerial act. I don't think anyone in this courtroom would say, how do you respond and whether you respond to a request for public information is ministerial.
But don't we take that as true?
Excuse me?
Don't we take that allegation as true at this stage?
No, that's a legal conclusion. That's not a factual allegation. So you look at, okay, well, what does this public statute require? You have to, first of all, it starts off with criminal investigation information is not public under A. Then we go to C, and it says, well, this information is public. And then we go to D, which says, however, you can withhold the information if you feel that it endangers the complaining witness, and that you, the responding public entity, can go to court and seek a court order allowing that information to be withheld and not disclosed again, and it automatically goes to the top of the docket and shall be immediately heard by the trial court and then by the appellate court if it gets there. You also have a section under this statute that says that the sheriff's office can withhold the information, move for court order if it feels that disclosing it will endanger the state's ability to prosecute the case or endanger the defendant's right to a fair trial. So we think under both of these doctrines that Judge Rozier's ruling should be affirmed. So I've gone over my time. I apologize to my co-counsel. Be glad to answer any other questions the court may have at this time. Thank you, Judge.
May it please the court and judges of the North Carolina Court of Appeals. My name is John Buchan. I represent Defendant Appellees WTVD Inc., WTVD Television LLC, and WTVD reporter Shane Dieter. With the court's permission, I will refer to them collectively as WTVD. With me today is my co-counsel and colleague, Natalie Potter. Your Honor, the undisputed factual background is important. It's set forth in WTVD's brief at pages 1 through 3 with citations to the record on appeal, and we've addressed that to some degree, but I think it's so important that we have this squarely before all of us. I'm going to run through it here quickly. On August 14, 2019, the Wake County Sheriff's Department issued a warrant for arrest, charging Wesley Walker with assault. Ed Crump, WTVD employee, came across the arrest warrant in his daily review of recently filed criminal charges in Wake County. And Crump, on August the 15th, 2019, sent an email to the Wake County Sheriff's Department Public Information Officer Eric Curry at his official wakegov.com email address with a request about Walker's arrest for assault. Crump asked this: just asking for a quick check to make sure this charge isn't related to the guy's job. He lists his employer as Capital Nursing. I'm guessing it's domestic, but if it's related to a client from Capital Nursing, I'm interested in more details. Shortly thereafter, Public Information Officer Curry emailed his response to the inquiry. It came from the wakegov.com email. His signature block was Public Information Officer, Wake County Sheriff. The response was, as the court has already mentioned, quote, related to his employer. Later that afternoon, WTVD aired a brief news report about the assault charge. I think the court read earlier the 5-sentence broadcast that was set out in its entirety at pages 2 and 3 of our brief. As the plaintiff's counsel acknowledged, the only sentence in the broadcast that plaintiff contains as false about his client is the sheriff's office telling us the charge is related to his job.
One quick question, and I don't know, I can probably find it in the record, but can you tell me how long the time between when your reporter sent the email and when the email came back? You said shortly thereafter.
Your Honor, yes, it is in the record, and I believe the email went out to the Public Information Officer at about between 7 and 8, and it came back, I remember now, at 11:38 a.m. So that was the time frame between this.
So a few hours.
A few hours, right. As we know, Mr. Walker sued WTVD for defamation based on WTVD's accurate news report of the Sheriff's Department's inaccurate report regarding the arrest warrant. This is precisely where the fair report privilege comes in, and this is precisely what it's designed to protect, to allow news media, and really for that matter other members of the public, but to allow news media who are provided information from government records, from official government folks like the Public Information Officer. It's permitted, it's to protect them. Well, first it's to allow them to rely on that information and report it to the public without, if it turns out to be false, without being subject to having to defend or, for that matter, perhaps lose a libel suit. That's the whole basis for the fair report privilege. It's clear here what WTV did. It was very careful. It attributed its broadcast of that statement to the official statement from the Sheriff's Public Information Officer. He used, the TV station used almost the exact words from that written official record. Here's what they said. The Sheriff's Office telling us the charge is related to his job. They didn't say, we know that this is true. They didn't say that. They didn't say, we have no doubt about this. They made it very clear. We're relying on what the Sheriff's Department is telling us that it's related to his job.
Plaintiff argues that under the Republication Rule, you still have liability. Can you talk about that?
Sure, Your Honor. The whole point is that the Republication Rule is if we had just said that, the Republication Rule would apply. We said that, but that's why we have the fair report privilege. The case cited early in our brief in the Ruber case from the Fourth Circuit explains that very clearly. This is to avoid the harsh effect of the Republication Rule. The policy is we want to encourage news media to report on government records, on indictments, on arrest warrants, on information provided about those documents from the public officials. If not, newspapers, broadcasters would not be able to report about any of this without fear of it turning out to be wrong and then they being sued for it. That's where the fair report privilege is critical. And it's a critical doctrine. In North Carolina, there are only 2 cases really, but all over the country, that is what protects what news media do every day in reporting on information coming from government about things like arrests or criminal indictments.
Could you address the plaintiff's argument that you had other information that he wasn't,
Yes.
that did not, and
Yes.
that therefore that takes you outside the fair reporting?
Exactly. Your Honor, that's an allegation in the complaint. It's taken as true. Doesn't mean it is true, but it's taken as true for purposes of this hearing. He uses that when he argues about fairness. Remember, he said there are 2 issues he's got, and I really want to be sure I get to address both of them. One of them has to do with the cases Burke from Tennessee and the case Thomas from New Hampshire. I want to address that, but that's a different issue. He talked about fairness. He cites 2 cases, important cases, Schiavone from the Third Circuit and Costello from the New Jersey Supreme Court. The fairness doctrine the fairness issue as it applies to the fair report privilege, and the cases, we've set this out really clearly in our brief, fairness has to do with whether the report, the news report, is an accurate and fair in the context. Is it a fair report of the official document? It's not whether the article itself is fair based on other information that the news media may have known. Here's what comment A to the restatement says. Abuse of the privilege takes place when the publisher does not give a fair and accurate report of the proceeding. That is, in this case, the email it issued. It's not whether the article itself. I do believe that plaintiff's counsel has confused the sense of fairness of the article. That's not the standard that relates to the fair report privilege. The fair report privilege says it is fair if the news report, this case, related to his employer, if that's exactly what came from the official record, in this case, the email from Eric Curry, the public information officer. If that was not the case, Your Honor, if that was not the case, in fact, the restatement's very clear that even if the publisher becomes aware that the government report may not be true, the publisher who accurately reports its contents remains protected by the fair report privilege. We cite cases at pages 15 and 16 of our brief, very specifically holding that point. If the fair report privilege could be disputed each time a plaintiff alleged that the overall article, and that's what the plaintiff is saying here, that the article wasn't fair because the TV station did not include the information from that it allegedly obtained from Capital Nursing. If the fair report privilege could be disputed each time plaintiff alleged the overall article was not balanced or fair because it failed to include something the story subject thinks should have been included, the fair report privilege would be undermined in its entirety. Every fair report privilege case would end up as a factual dispute over the fairness of the article. That's not what the fair report privilege permits. It does say that the news report must be fair in that it can't misrepresent the actual document that they're relying on. In this case, the news report is almost verbatim the information that they got from the public information officer. When you go back to what the fair report privilege does deal with when it talks about fairness, look to Schiavone and look to Costello. In Schiavone, the court found that the news report was an unfair rendition of the government report it issued. There, Time Magazine had reported, based on government records, FBI records that they had obtained, they reported that Schiavone's name appeared several times in an FBI report about the disappearance of former Teamster boss Jimmy Hoffa. The magazine did not include, the court said, the important information that appeared in the government record, not outside the government record, but they failed to include information that was contained in the government record that quote, none of these appearances in the Hoffa execution files suggested any criminality or organized crime associations.
But bear with me a second, and,
Sure.
and maybe this isn't quite the facts of this case, but had the media outlet received an arrest warrant, a report, police report, departmental report, and then, but nevertheless had actual knowledge that that report was in fact false, but yet proceeded to then to broadcast or disseminate the statements in that report.
Your Honor, that is, I'm sorry.
Would that change the analysis?
No, it doesn't, Your Honor. In fact, comment A to the restatement.
But would that not, I mean, if the media outlet here knowingly made a false statement about somebody.
Yes.
Would that not
Your Honor.
be defamatory?
Your Honor, it might be defamatory, but it would not be actionable because comment A to the restatement of torts, and cases cite this repeatedly. We cited these cases in our brief. The news media does not have an obligation to go investigate further. It does not have, even if it has been given information that perhaps that information is not true, perhaps the story subject calls them up and says, it is not true, I deny it. That doesn't stop them, and that's what the policy behind this privilege is so important. We're allowed to rely on the government documents, the government reports, the government arrest warrants, the indictments. Those things often turn out not to be true, and the publisher may often have information that they're not true. But what comment A specifically says, that even if the publisher knows them to be false, they can report those and be protected by the fear of report privilege.
And the cases I believe you cite are from Pennsylvania and Connecticut and
Right.
Texas. Is that correct?
Right. I'm sorry, Your Honor. Thank you. The two cases that I wanted to distinguish, thank you, on the other point, having to do with, well, this is, let me just tell you quickly, Your Honor. I did lose a little bit of my time, not by my fault. Your Honor, we didn't get to, those were cited only in the reply brief, and so I want to address them as quickly as I can. In Burke, the court rejected the
I'll give you another minute, and I'll give you an extra minute as well.
Thank you. The court rejected the application of the fair report privilege to a news report based on a, quote, non-public, one-on-one conversation. The Tennessee court repeatedly described it that way. It was not a written communication, not a recorded communication. And in the end, the court focused on the fact that this was an oral communication. And given limited time, I'm going to go quickly. If the court would look at 592 Southwest 3rd at pages 123 and 124, here's what the court says. It's key to their decision about why they ruled the way they did. They said, lawyers, judges, and litigants would have no objective means of determining the fairness and accuracy of a report derived from a non-public one-on-one conversation. Only the parties would know what was said in that conversation. And every assertion would require testimony from the parties as to the conversation, would require an assessment of the credibility and the context of the litigation, that the report was fair and accurate. And the court, that was the basis, and it's important when you look at that decision. It didn't involve an email, it didn't involve a written document. Of course, it wouldn't make sense to rely upon an oral conversation when nobody knows except those two people what it says. That's a far cry from what we have here. We know what the facts are we have here. Quickly, the Thomas case from New Hampshire, again, it didn't involve an email or any form of written document. The government report were oral conversations between police officers and the reporter. More important, the court, and I refer the court, please look at this. At 155 New Hampshire, pages 330 to 332, the court says, the conversations with the law enforcement officers were not official. That is, the communications did not come from someone with authority to be speaking officially to the reporter. The court said the officers who spoke to the reporter had, quote, not been given the official imprimatur of their departments to function as spokesman or even to speak with the reporters. And they elaborate on why that's important. We don't have that here, Your Honor. It's not like Burke and it's not like Thomas. Here we have the written document that says exactly what information came from the government. The WTVD relied upon that as the fair report privilege allows them to do. Again, that's the point of these privileges. It turns out to be false, but they're protected because they did what they were allowed to do under the privilege. Thank you.
Thank you, Mr. Becker. We'll hear from the appellant, and you may have 2 minutes and 5 seconds after your time runs as well.
Okay, that's fine, thank you. I may not even speak that long if I'm lucky, but just to address a couple of the points and arguments I've heard here. With respect to the sheriff's arguments, I didn't get to this in my initial presentation, but there's been some argument in both of the briefs of the sheriff and the news media about how does the public records laws apply here. So all of us have briefed this to some extent. The positions taken by the sheriff's office seems to be, oh, we had no choice. Our hands were tied. We had to give them this information when they called. And Your Honors asked some very good questions during the argument. Where did this information come from? How do we know where this comes from? Those are critical questions. And again, this case is at the pleading stage. We haven't gotten to discovery. We haven't gotten to that level. So a couple of points I'd just like to clarify. There were some statements made here at the argument, as well as in the briefs, to the effect that there was a statement that Mr. Curry, quote unquote, reached out to CID. I do submit that is not in fact in this record. And I mentioned this in my brief. What I contend is and is not in this record. It would be the pleadings and certain documents attached to these pleadings. But some of what we've heard here is not in this record. That's an example of one of those I would contend is in fact not in the record. But the other point I would make is this. What it seems happened here is Mr. Curry, and again, these details aren't in this record, but he went and did something, got some information that this was related to my client's employment. We do have this somewhat peculiar distinction between us today about is there a difference between a record and information? And we submit there is. We've put this in our brief. The sheriff seems to contend that if someone calls up and asks for quote-unquote information that's not in a record, they have a 100% absolute obligation to give that out.
Well, not someone, but the media.
You know, it would be the media. That's correct. I would note, I don't know the arguments in this case actually depend on them being the media. I think these arguments would apply if it was just a citizen calling. But yes, in this case, it was the media. But their argument is they had an obligation to turn this over. I submit that is flatly incorrect. If there is a true public record, and public record, a record means a document. It can be a paper, it can be a recording, a video, but it's something tangible. It's
Well,
not
how
just-
do you address the argument from Mr. Ellis that the Public Records Act addresses information as well, which is different than documents? Can you address that,
yes.
please?
So, and there's and I'll be getting down pretty far in the weeds if I talk too much about this, but within the public records laws, and both sides have cited to this, and I have put the citations in my brief, and I think even a footnote, there is a reference to information within the Public Records Act. What we submit is that where this term appears in the Public Records Act, what they are saying is they're addressing, the legislature is addressing when they go in and redact information from a public record, what quote-unquote information are they still required to disclose? And so our position is, yes, there's a reference to information, but not all information is a public record. Their argument seems to be information is a public record. You have to sort of look at that in context. But it's not called the Public Information Act. If you contact the government and say, what do you know? What do you think? They have no obligation to say, well, let me think about that. Here's what I think. Here's what so-and-so said. It's records, documents, tangible things. That's what they would have had to produce. So if they had just produced an arrest warrant, an indictment, that sort of thing, this would be different. But I submit the Public Records Act absolutely did not require them to tell the media this was related to his employer. They could have simply said, well, we'll give you the documents. That's all we have to do. We're happy to do that. In fact, I quote a case in our brief indicating that law enforcement, as a general matter, has no obligation. It's cited in our brief, no obligation to provide information other than as required by something like the Public Records Act. So that would be the basic analysis, and we would contend they didn't have to. So I wanted to clarify that. I want to clarify that issue. Just briefly, I'm down to about perhaps a minute or so. I'm sorry. Is there a question?
You've got, no, you've got 2 minutes.
Okay.
And 40 seconds.
Okay, thank you. Just to briefly address some of the arguments about the media's arguments here. When Mr. Buchan was arguing for the media, he referred to things like an indictment, an arrest warrant, forms or documents from government officials. He referred to the official document. If that's what we were talking about here, I would submit this is different. Our position is fundamentally there is a difference between an email and an official document. Under their argument, a police officer or any one of a number of government employees could write on a napkin, I heard that so-and-so killed so-and-so, or I heard that so-and-so did X, Y, and Z. And all of a sudden, they could take that, they could report it verbatim, and they would cloak themselves within that shield. Our position is, as supported by the cases we've cited, that it does not extend that far. There's also been an argument made here about whether it makes a difference if it's a conversation versus something in writing. The cases we've cited do address this point. Just very briefly, my time is low. We cite, for example, this case called Thomas. The Thomas court wrote, documents authored by police officers do not become official or matters of public record simply because they may be located in the police department. Another case we cite is a case called Wynn versus AP from Nevada in 2020. That court held, quote, to hold that a law enforcement officer's mere transcription of a complainant's allegations warrants application of the fair report privilege would be inconsistent with the underlying policy. So even if things are put in writing, that does not make it an official report such that the media can then write that. And of course, the other point we've talked about is whether it was fair and complete. Both sides seem to put some weight on the Costello case, the Chiffon case. I cite Costello as authority that would, in order for them to prepare a fair and complete report, they do have to, in fact, present exculpatory evidence, even if it's outside of the document they're relying on. Here, they had the information that was exculpatory, and they chose not to publish it, and we would contend that is proper consideration as to whether that doctrine applies. I think I'm out of time, so unless there are any questions, I'll take my seat.
Thank you. Thanks, counsel, for good arguments.
All rise. This session of the North Carolina Court of Appeals is now adjourned.